Welcome to everybody. Thank you for joining us. Today we present a virtual fireside chat about the benefits of working with experts as part of a legal team. Our participants will discuss the particular contribution police practices and use of force experts can make, both at the trial level and in the post-conviction setting, and they'll talk about their experiences in wrongful conviction cases. This conversation will encompass roughly the first hour of the program, and the final half hour will be reserved for your questions. So at any time during the program, if a question for our participants comes to mind that you'd like to ask, please just type it into the chat. And during the question and answer time, our participants will answer as many of your questions as we have time for. So let's meet our participants in today's program. First, Mr. Timothy T. Williams, Jr. is an author and a leading national expert on police procedure, use of force, and wrongful convictions. He has over 29 years of active law enforcement experience and over 40 years of experience working in the criminal justice system. Mr. Williams proudly served on the Los Angeles Police Department as a detective, ultimately ascending to the rank of senior detective supervisor and retiring from the elite robbery homicide division. Mr. Williams is currently the founder and CEO of T.T. Williams Jr. Investigations, a company based in Los Angeles, California, that provides industry-leading expertise in cases throughout the United States related to police procedure, use of force, and wrongful convictions. Since the launch of his consultancy practice in 2003, he's provided expert testimony in more than 200 cases and analysis of over 1,200 cases, including several landmark cases. We also have with us attorney Paula Mitchell. Professor Paula Mitchell is an attorney and the legal director of the Loyola Law School Project for the Innocent in Los Angeles, California. She's also the executive director of the Alarcon Advocacy Center at Loyola Law School and the supervising attorney of Loyola's Ninth Circuit Appellate Clinic. She works with and trains law student advocates and other attorneys committed to investigating claims of innocence and wrongful conviction, including investigating innocence claims and drafting habeas petitions seeking to overturn convictions and obtain release from custody. Ms. Mitchell believes in righting injustices and bringing about much needed reforms in our justice system, particularly on behalf of segments in our community who are traditionally underserved. And my name is Adam Grant. I'm the program director at the Loyola Law School Project for the Innocent, and I will be hoping to host this afternoon's program. So without any further introduction, Tim, you wanted to say a few words to start us off.
Yes, first of all, I want to thank everyone for attending this fireside chat. And as Adam stated, we will be discussing and getting into what a police procedure, use of force, and wrongful conviction expert does and looks like in these criminal matters. We'll talk about the importance of putting experts on a case, and I'll be sharing with you some outcomes that I've experienced in doing this work, both in law enforcement and in my private practice here. For a total of, this is my now 47th year doing this. So I'm having fun doing it, and Paula, let's get started.
All right. Good afternoon, everybody. Thank you for joining us. So I am the legal director at an Innocence Project at Loyola Law School, and we know firsthand how incredibly valuable working with an expert like Tim is on our cases. But Tim, why don't you tell our attendees, what does a police practices expert do? What do you know? How can you be helpful to criminal defense attorneys?
Sure. A police procedure expert is basically analyzes the case from the genesis or the beginning of the case. Look from the radio call, if it's a radio call generated case, or what the officers did to observe whatever it is they observed as it relates to starting the case. And we look at it, and I look and see what the first responders are doing. I look at the the supervision as it relates to the first responders, and then I get off into the investigative aspects of the case, what the detectives were doing during the course of their investigation, up into including the filing of the case. There are a lot of times we look at and see, we look at the areas of the case as it relates to the supervision of the investigation as well. One of the things that I will say that, so that one will know, an expert is not an advocate, they're basically a teacher. And as we get into more of the discussion, we will see how all that is translated. But basically what I do when I get a case, I do a triage or a biopsy of the case from the very beginning up until to the conclusion. And if there's a wrongful conviction, I look at all aspects of it during the trial as well, giving my expert opinion on the findings of that case. Paula?
So I know one of the very first cases we worked with you on, it was my very first case when I came into this current position. And so I was in need of a lot of teaching, and you were incredible in that regard. And when we called you to ask you, what should we do? How do we go about this? One of the first things you asked us to do was see if you can find the policy manual for that year, the homicide manual or the detective's manual. And just basic things like that were incredibly helpful. Why don't you talk a little bit about what sorts of things you like to have to review in front of you, how you need people to work with you, and what materials you want from them in order for you to be helpful?
Sure. What Paula was talking about was a wrongful conviction case, but it had some age to it, if you will. And when you deal with those cases, you have to get the discovery or the documents that were in place during the time of the incident. If something happened in 1993, if you look at policies and procedures for 2001 or 2021, you're not doing the attorney or the client any service. You've got to look and see what the policies were at the time of the incident. And what's important is you need to have an expert that has some historical or history behind him or her. In other words, person that has time and longevity in an investigative field. I have over 26 years of active investigations when I was with LAPD. So I kind of know what was out. I do know what was out there during that time. I do know about the policies and procedures, and I do know what the investigative nuances were during that time. Not only in the city of Los Angeles, but throughout the country, because I worked on cases when I was with the department in different parts of the country as the case took me. So the thing is that you've got to, if there's a detective operations manual that was in place, you got to get the detective operations manual that was in place during that time. You have to get a policy manual that was in place during that time. And all agencies have these documents because of lawsuits and other issues that may come up over the years. So they have to maintain a library of these documents throughout. Now, there may be some situations that may be nuanced to the attorneys, but the expert should know about as it relates to training. So one of the things that I do, I suggest that they get all the training records during that time. That was important. A lot of times you see individuals working assignments that are very critical, and they don't have the continuing education requirements or the professional schools that require them to work those assignments. So that's very important in the attorney to point that out, so the attorneys can address those issues as they're looking at the case to further litigate it. So having an expert is important because the information that they will provide to them through discovery may be information that they may not know about. Let me give you an example that I cite about in my book. I had a case several years ago in San Francisco, and it's a wrongful conviction case. and the attorneys sent me 12 bank boxes of discovery. And one of the issues that we were talking about is Brady, and I'll let the attorneys talk about Brady more in a legal term, but is basically as law enforcement giving exculpatory evidence through the district attorney so that they can pass on to the defense. And one of the things I was looking for was a Brady training. And I think in box 11, I found a little piece of paper where the detectives had the Brady training. Well, Brady was a major issue in this case, amongst other issues. So that was important, so that, you know, that I knew during that time of the different types of trainings that was going on nationwide as it relates to detective functions. And so that helped them in that case. The second thing was that, as I was telling you, that you had to have policies and procedures that was current in the time of the incident. The opposing expert would have report that was based upon policy and procedure that was current at the time of the writing of the report. My report was based on what was the policies and procedures in the late 70s and early 80s when this situation happened. Long story short, the case settled based upon my report, and it allowed the plaintiff to receive a good financial outcome as it relates to that. So that, again, it's important that experts and attorneys talk, make sure that we get the proper type of discovery so that they can do what needs to be done. Paula?
Yeah, I wanted to talk about a little bit more about the things that we learned from you right off the bat. You know, when we worked on our first case with you, you pointed out in what we call the murder book or the police records that you know, this report isn't signed by a supervisor, or this report, there seems to have been some whiteout in this report. All kinds of things that we didn't necessarily know. They looked sloppy to us, but we didn't know what the significance of them was necessarily. Another example is a case where we worked on with you, where when we asked you to look at the videotape, or actually the transcript of an interview with a witness in the case, one of the people who was participating in that interview was a commander at the police department. And you said to us, what's the commander doing in there? What's the commander doing taking part in an interrogation, essentially, or an intense interview? And these are all things, you know, you talk about in your book, that an expert has to have not only detective experience or experience as an officer, but experience as an administrator, and know the chain of command and know the significance of how they're using the chain of command or misusing it. So can you talk a little bit about those other areas and how a lawyer can use that information to help their client?
Yes. Going back to the reports, it's important in different aspects of the investigation that, like when you present a case to the district attorney or the city attorney or the prosecutorial arm, that supervisor reviews that document and making sure that everything is in place. It's a check and balance. And then he or she will sign up on it. There's a box on the report where it says supervisor's approval. A lot of times you don't see that box being signed. You know, the detective will put together a case and they will send it to the district attorney or the city attorney's office if it's a misdemeanor, and they will proceed from there. I was raised up in the era in my generation that the supervisor signed those reports prior to it going to the district attorney or to the prosecutorial arm. But now you don't see that. Even during my time on the department, there was a good portion of the time that there was lack of supervision, a supervisory oversight in that. Now, why is that important? There's always a final report that's written after the case is filed. And if you don't read the report in its entirety, you look at the first report, and then you see a second paragraph or a second or third paragraph that talks about, I submitted the case to the DA, Jane Doe, and John Doe. They looked at it and they filed 2 counts of murder and then 2, 3, 4 counts of assault, so on and so forth. And then the case is closed out. But somewhere embedded in there may be some changes as it relates to the investigations that were done, maybe a variation to an interview that wasn't talked about in the initial report, and some things that the district attorney may have caused the detective to do to enhance so the filing won't be challenged, the case won't be challenged in court by the defense. So if you don't read that, just read that one report, you'll miss that. And that makes a big difference. So what you have is 2 different reports. And now you as an attorney, you can attack the detective or just the detective as it relates to, well, Detective so-and-so, we have 2 different reports here. You got one that you submitted to the DA, and you got another one that you submitted in conclusion, which one doesn't have a supervisor's report signature on it, another one does. Now there's a problem. Now you have 2 different reports with 2 different issues. What am I to believe? This report here without the supervisor's signature, or this report that adds some more additional information with the supervisor's signature? So that's important. So to know that, and a detective or an expert who has longevity in investigations will immediately pick that up, and also one that has been a supervisor in detectives and has worked at the staff level would know these types of issues. The second thing you talked about is about staff officers getting involved in investigations. I have read investigations all across this country, and I can tell you without a doubt when staff sticks their nose into an investigation, because it all ends up wrong. And these are guys that have stars and bars on their collars, and they have some real high profile case, and they want to get their input into it and it just gets screwed up. And I consulted with you with one case where a commander was involved in an interview. Why is he involved in an interview? He has no training, doesn't know anything about interviewing techniques, and perhaps doesn't even have any investigative background. Well, now you can, when you get that case and you start litigating that case, and if you have that commander understand, you can have a field day with him or her. And as far as to the credibility of the investigation and the expertise that's involved. Also, too, let me say this: a lot of small agencies do stuff that they shouldn't be doing. You have small agencies that try to handle big cases. Well, there's mutual aid agreements with those small agencies to the big agencies. And why is the mutual aid important? Because big agencies like the sheriff's department or the county sheriff's department may take over those murder investigations, those investigations that require a lot of resources. And they have the expertise, whereas the small agencies may not have that expertise. So you got to know administratively how law enforcement agencies work, how the big ones work, how the small ones work, and you explain all that in your analysis of the case. And if you're wrong here, where else are you going wrong in? You see, so those are the things that are important. And again, if you have an expert that all he or she has is patrol experience, and no detective experience, no lengthy detective experience, and very little or no management supervisory exposure or management exposure, then you miss a lot of stuff that you would not normally miss.
So let me just follow up on that. Your first point, when we were talking about the records, if you have isolated records that are not signed by supervisors or seem to have been corrected and so forth, and you see that those are problems, those can obviously indicate a range of different problems, some of which could be that they don't want their supervisor to see what's in the report, or, some of the things that you enumerated. As the expert, how do you go about determining what this really indicates? Something like
it could end up being shortcuts. If you work with an agency or you have a case with the agency that has a consent decree issues on the agency, that's critical. You need to pull that consent decree and see what it has to say about the investigation, and you may be surprised. And I've had those type of cases before where consent decree was a major issue in the case. The judge knew about it, but the apparently the attorneys didn't know about it, and they couldn't get their experts qualified to testify about the case. So the thing is that, you know, you've got to, that's why it's important. You got to know your craft. You got to know what's going on in the criminal justice system. You got to know what agencies may have consent decrees, and you talk about that, and all that's part of the discovery request. You know, if there's a consent decree, you want that information, you want that consent decree given to you so that you can see. Let me give you an example. LAPD, where we had the Rampart scam. And with that, you know, they had certain things that had to be in place. One of the things was the booking approval. Well, prior to that, only one person gave the booking approval was the watch commander and or sergeant. Well, now, even to this day, now it's required 2 signatures. One from the detective supervisor, and the manual is very clear. If that supervisor is not available, then you make a phone call and wake him or her up out of bed and get that approval, and then they'll watch commander. And if you, as I review these booking approvals, I would say less than 50% are in compliance. Less than 50% are in compliance, and that was a major scandal for the department. So there are shortcuts that are in place, and in law enforcement, or in aspect in any discipline, where costing municipalities millions and millions of dollars, you find that there's been shortcuts. You find that you have personnel in place that shouldn't be in place because they don't have the requisite background and skill sets to be in there, and that's why it's important. And we will get to the lawsuit a little bit. That when you bring the lawsuits against the departments, that not only you deal with patrol officers and their supervisors, detectives and their supervisors, but you got to bring mid-management and managers into, because they sign up on all this stuff, you see, and even internal affairs. Now, you know, the worst investigators that I've seen in this stuff, and I've seen a lot of stuff throughout the country, is internal affairs investigations as it relates to criminal investigative activity, and they will rubber stamp everything that's going on, and you find out that these investigators that work in IA, internal affairs, they don't have the requisite background to even know what they're investigating. So, you know, and that's where the experts come in that have the experience, so to guide and direct you throughout those issues.
Well, it sounds like you've seen a lot of shortcuts and rubber stamping over the course of your career. Why don't you talk a little bit about your various positions at the LAPD, and you know, how did you handle it when you saw shortcuts or rubber stamping, or somebody in a role that they weren't properly trained to be in? And then also talk about why you decided that you wanted to do this kind of work after you retired.
Well, when I came on the department in 1974, I started working patrol, and from there I went to the academy. First of all, I get trained. I went to the academy, then I went to my first patrol assignments, and where I did my probation. My second assignment, I was working Employee Opportunity and Development Division, and that was basically the recruitment arm for the department. My likeness was utilized as a recruitment tool for LAPD for about 10, 11 years. And my picture was basically displayed all over the world, as well as a lot of TV shows, police TV shows in the 70s. If you look at the old Dirty Harry movies and all that stuff, you see my picture in the background. So,
really?
but I had to sign off on that before so that I wouldn't get any money for that. So before. So to answer the question, I got zero money for all that stuff. So I went from there. I went back to patrol, and I've always wanted to be a detective, so I decided to go. I took an interview and was selected as a detective trainee, and then from there I began my detective career. My assignments that I have worked was robbery, homicide, crimes against persons, juvenile, auto theft, burglary, sexual assault, domestic violence, and narcotics, just to name a few. I'm sure I missed something. On the administrative side, I was an adjutant. An adjutant is aide to a commanding officer at the divisional level, and I was adjutant at the staff level. At the staff level, I was at Detective Services Group, and we had functional supervision of all the detective functions on the department. And in that seat, I got a lot. I was able to do a lot of different things as it relates to how things were done. I looked at very closely the lawsuits that were coming through the department at that time, especially as it relates to detective functions, and a lot of the things that were being done and weren't being examined. When I say being examined, they weren't being audited. So it caused a lot of audits to be done throughout the department, which caused a lot of consternation because when you get down to the bureaus, somebody had to do those audits and get us some answers as to what's going on. But we saw a decline in some areas as it related to risk management issues by examining those areas. One of the things that I was at that level, I was the department's expert in domestic violence, hate crimes, and I forget one other area that's escaping me now. But those are things that immigration issues, and so those are things I had additional expertise on. Why was I a domestic violence expert? Well, I created a domestic violence expert on the department in LAPD in 1994. In 93, I did an audit, and I was looking at crimes against persons. So I came in one Sunday, and I looked at what we were doing in the division I was assigned to, and I found that in the crimes against persons, over 60%, about 63, 64% of the crimes that we were investigating was domestic violence related. So from there, I wrote a proposal and submitted it up the chain of command. It hit a ceiling, bounced back. So I did a zig and a zag. And Chief Willie Williams came in at that time. He thought it was great. One of the police commissioners I knew thought it was great. And it was embraced. I ran the first pilot program for the department, and it was called the Major Assault Crimes Unit. And at that 1994, the detective function was reorganized, the first time in 50 years, to embrace domestic violence as a singular focus. And so that's my legacy I left behind, and that will be in place long after I'm gone. So I did leave my mark on the department. So those are the things that I've done on the department. Now, the question was, how did I get into this business? Well, when I retired, it was supposed to be a private investigation firm. So all the defense attorneys I was going up against, they called me to help them with their cases. So I retired on October 13th of 2003. My phone was ringing on October 14th from these attorneys. So I'm doing my investigations, doing what I'm supposed to do, and I'm testifying in court. And I'm testifying on procedural issues, not on what I've done in an investigation. So I said, wait a minute, they used me for something that I'm not, that I wasn't out there doing. So I wrote a proposal to the presiding judge at that time in CCB, the Criminal Courts Building, and he embraced it. They put it on the Los Angeles County Superior Court expert witness list, and I was the only expert in police procedures for approximately 5 years in LA County. Well, this is a new phenomenon in the criminal justice system for criminal work. And in that you had experts, especially in dealing with police procedure on the civil side, but never on the criminal side. Mm-hmm. So I'm sitting up in court testifying about procedural issues, and the district attorney is having fits. They're objecting to this, objecting to that, and having sidebars. And I'm hearing judges say, I don't know what to do. I've never been exposed to this before. And so they making rulings on that. But long story short, it transitioned to the point where now I'm getting calls from all across the country to help with criminal issues as it relates to police procedure. So this was something that has changed throughout the department, not only the department but throughout the country as it relates to how you address police procedure issues. When I was doing the work, no one ever challenged my work other than the defense counsel, and I didn't have no one coming in, or no one came in for that matter, for anybody that was challenging police work in the criminal side. So that's how I got started.
Well, I'm dating myself, but I grew up watching Mannix and I don't know, Cannon, and I've seen all the Law and Orders. And I mean, before I met you, I thought I was pretty good about what police are supposed to do and police procedure. But it turns out, like most people, I really, really had no idea until I started working with you. I know that wrongful convictions are one of your passions, and I know that you have worked on those cases because you have actually helped our project with some. Can you tell us a little bit about some of the cases you've worked on, innocence cases, and why you're drawn to them?
Yes, I have worked. Well, one of the biggest cases I've worked out was out of Chicago with their innocence project at I think it was Northwestern Law School, and in Chicago, and it was the Inglewood Four. And these are individuals, young men who were tried. Well, they were arrested for a rape and murder for a crime they didn't commit. And I read that case, and it was just, the investigation was terrible, the coercion was terrible, and it was just a terrible investigation. So I was asked to be a part of that, and they flew me to Chicago for my first deposition, and I walked into the conference room. There was about 15 attorneys in there about, and they all come looking at me. So I have four. I'm representing, or not representing, but speaking on behalf and doing my analysis of four individuals there. And then they brought me back a month later to finish up the deposition. Long story short, based upon the report and the depositions, the case finally adjudicated itself and made those gentlemen financially whole. You can't bring back the time they spent in prison, but it made them financially whole. The second one was again working with the Innocence Project out of New York. They had a case here. I consulted. I did not testify in that case at all, but I consulted with them and was instrumental in helping them get a settlement without it going to trial. Again, directed them on what to get in discovery, what was going on back in the 70s, and because this gentleman almost spent pretty close to 40 years in prison for a crime that he didn't commit, a murder he didn't commit. And that's the case settled for at that time one of the biggest settlements in the history of Los Angeles. But I've done that. I've worked with your Innocence Project. I've worked with other agencies in San Francisco, big law firms there, and dealing with wrongful convictions. So your name gets out there a little bit, and if you have good outcomes, then people want to retain you. And so it's very hard work, long hours, and it's not for the faint of heart. I tell you that much.
So you talk in your book some also about the need for experts to have continuing education and to stay current on all the issues. You also talk somewhat in your book about the need for experts like yourself to be able to identify other areas where experts need to be brought in, for instance, in forensics and so forth, forensic evidence. Can you talk about a little more about how you as an expert can help to identify other areas where an expert might be needed, and how that causes you to need to stay educated on a variety of things?
continuing education is very critical, and especially when you work in some very high profile assignments or doing high profile cases. I'm going to share two cases with you. One is when I was working with the department and why an importance of continuing education, and one in my practice. When I was assigned to child abuse, you weren't given in that time, and I don't know if it's still the same way, but you weren't given the requisite training that you would need to do the type of cases that you needed to do. So I saw immediately that there was a big void there, and a lot of stuff you got from detective school and a lot of stuff you got from detective supervisor school. But there is, especially when you deal with children and violence against children, there are a lot of nuances that you don't get in those type of schools. So what I did, I was going to Children's Hospital, sticking away to Children's Hospital and going to the doctor's training, and especially when it comes to trauma and things of that nature. One lecture I had was a lecture on osteogenesis imperfecta. That's a brittle bone disease, and it was fascinating the training that I received, and I said, well, I probably won't get any case like that, but it's good information to know. About 4 or 5 months later, I got a call from a patrol officer in the field, and he says, "Hey, detective, we got a case here where um, this baby has about 4 or 5 broken bones." And I said, "Well, do you see any trauma on the baby?" And he says, "No, man, no. But it's 4 or 5 broken bones." I said, "Look, take the child." Well, the child was going to the hospital, obviously, but I think it was 2 other children. Take the children, but do not arrest the mother. Don't arrest her. I'll get the case when it comes through the next day. So they followed my direction. I got the case when they came through the next day. So I called a pediatrician that I knew that was at USC. I says, "I need you to look at this child, and if you rule out osteogenesis imperfecta for me." And he said, "What do you know about osteogenesis imperfecta?" "Well, I got the same training that you got." So he looked at it, and he called me back. He said, "Hey, Tim, the baby has osteogenesis imperfecta." Well, that training saved a whole bunch of issues that would take years to undo. Number one, if the mother had been charged for a crime that she didn't commit, she would have been in the system, and it would take years to get her out, you see. And the training that I received was so important because that phenomenon was picked up during the course of a child abuse investigation. Children went back home, the case was resolved, and the child was, they dealt with that and how to treat the child. So that was important. That's why continuing education was so important to me during the course of my investigations there. And I have so many other stories to tell. But the next thing is on my practice is we had a case of a drive-by shooting. It's talked about in my book, a drive-by shooting where the defendant's DNA was on the gun. Wow. And I said, that was a murder case. And, you look at it from the onset, it's almost like a slam dunk case for the people. So I'm reviewing the case, and there were some nuances of investigative issues that I saw, but it didn't eclipse the issue of the DNA on the gun. So we had a defense meeting, and I suggested to the defense counsel, I said, "Look, we need to get a DNA expert in here to look at this stuff and to see, what the people are laying their hat on, see if the science is in fact correct." So we got a hold of a DNA expert. The court appointed them, and we sat down and we had a second meeting, and I said, "Look, we need to do a deep dive and look at this discovery." Well, the deep dive was done, and you found that what they were looking at on the electrophorograms, those are the squiggly marks and charts that you see, that they were stutter marks, and that it was not good science that was being recorded. The second thing we found that was the coup de grace was that we found on the error log that the samples were mixed up. The samples were mixed up.
Mhm.
So we testified with the DA, the DNA expert testified, and the we went through there, and I testified in the court and about my findings. And long and short of it is the defendant was found not guilty. Now, if we didn't do that deep dive, if we didn't look and bring in another expert in there to look at that case, that person would have been found guilty of a murder that he didn't commit. That's why when I lecture to attorneys and there may be some law students on this fireside chat as well, is that you don't stipulate to anything as it relates to science. Always examine it. You don't stipulate to anything as it relates to investigative procedures. Always examine it. Because what you hear may not be what the reality is. You got to examine it. You got to get the proper expert in there to help you with that. And you may need additional experts besides a police procedure expert to do that. Needed a DNA expert because it was a DNA issue that we had. And so, and it worked out. And that's why it's important. And I got that from my continuing education. If I wasn't into continuing education and missed a lecture or lectures on DNA, I would have never known to talk about that and bring that into an investigation.
So we also hear a lot these days about tunnel vision. Can you talk a little bit about how tunnel vision affects a police investigation and what you can do about it on your end, on the post-conviction side?
Yeah. Well, a lot of times, and I have found this when I was working with the department. A lot of times, detectives will get focused on a one aspect of a piece of evidence or a focus on one direction in the investigation. And things may come up during the course of an investigation and they will resist making that shift. I call it an investigative paradigm shift. They may resist doing that. And you've got to be flexible. You've got to be flexible when it's out there. You may see an innocuous piece of evidence out there in the crime scene and it's sitting there in the evidence. And you say, wait a minute, I think I may need to look at that piece of evidence and get it tested and so on and so forth. And that may direct you into another arena. A witness that you were talking to, directing you to a suspect, that witness may be the suspect. You see, so the thing is that you've got to be, your investigation has to be so tight and so loose that you understand that you be able to adjust and adapt as things come up. If you have these blinders on, then you'll probably miss the forest for the trees. Sometimes you got to back up and elevate yourself to about 35,000 feet and then look at the thing from a different level and see, especially if you're having a hard time trying to solve the case. And when I look at the case and I analyze the case, I can see this right away. Hey, this person didn't commit this crime, and these are the reasons why.
Well, as a lawyer and an investigator and someone who's worked on these cases, that ability to pivot in an investigation based on the evidence seems so elementary to me. Why do you think that some police officers and detectives have so much trouble with that?
Well, how about police officers, detectives, and attorneys? They all have problems with it.
Okay, but where does it come from?
Well, the thing is that you have a theory, and you don't want to change your theory, and I've been doing this for so many years, blah blah this. You hear the bravado, and sometimes you gotta make an adjustment. It's like in the medical field. I go, doctors, they will diagnose you for a certain thing, and all of a sudden you get this treatment and it's not working, and another doctor looks at it and says, well, you're treating it for the wrong reason. This is why he has his problem. Well, you're not, and then you argue back and forth with the doctor, with the, and that's, you have that tunnel vision. A case, an example, I had a case, a pre-defendant case, I talked about that in the book too. The defense attorneys were on the wrong track, and they had their own theories, and they bring me in, and I'm looking at the case. It says, number one, you guys are ready for trial, and they're in trial. And number two, it says, you know, this, I can't testify to this because it's not correct. Your theory in the case is wrong. And I tried to explain to them. So, and I finally convinced them to listen. So I testified, and long story short, all three defendants were found not guilty. Now, they had ran on that track of I call it a fault line in their representing of their clients. The clients would have been found guilty, and then we had three defendants that would have been found guilty for crimes they didn't commit. It was a simple way of looking at things. You know, I'm not an attorney, and attorneys aren't detectives, but together we can put our heads together and come with a coherent answer, an approach to get things done. And I think, and again, I think that's important. We all need to loosen up our ties, so to speak, and take away those blinders, and you be surprised what you will see.
I'd like to ask a follow-up question about that, because in our work, confirmation bias is something we see in almost every case. And, you know, things like there's a crime and the police arrive and the investigation gets going, and, you know, they decide to collect certain pieces of evidence, but not other pieces of evidence. And all of these years later, when we're looking at the case, and if we have an opportunity to ask, you know, why didn't you collect, you know, that evidence? Why didn't you collect the contents of the wastebasket? And they'll say, oh, it wasn't relevant. Or we didn't need that. It's like the crime just happened. How do you know that it's not relevant? And so I guess my question for you is, how do you train investigators about confirmation bias or tunnel vision, and how to avoid it, or how to keep it loose, like you said?
Well, you got to, first of all, you got to define what confirmation bias is. It's a type of cognitive bias that involves favoring information that confirms your previous existing beliefs or biases. Give you an example. I like practical applications. You see a kid walking down the street in a minority community. He's sagging, and what's the first thing that you're going to analyze him about? He's a gangbanger, right? Now this kid is home on summer break from college. He's attending Harvard University, and he's one of these Phi Beta Kappas, and he's going to be going to Oxford for continuing education. Now this bias that you put on him could cause you to put other things on him that could cause him to be documented in a way that could cause him to be drawn into something that he didn't do, that can cause him to go to prison, and 25 or 30 years later you're getting him out and his life is just ruined. Okay, this is in my opinion, that's a prime example of confirmation bias. So the thing is that, and it not only happens in investigation, it comes from the bench to both sides of the table, from the defense to the prosecution, and everybody embraces these types of this type of bias.
Mm-hmm. It's hard. It's a hard thing to train for, because it is so, I mean, it's also sometimes called unconscious. And if it's unconscious, it's that you're doing it without knowing it. And so you mentioned the gangbanger, you mentioned Rampart. I want to ask you about some issues maybe that are unique to Southern California. LAPD, we have a gang database. We have LA Sheriff's Department gangs. Talk a little bit about things that you've seen in your work that are particular to Southern California and LA.
Yeah. Well, one of the things in LA, and it's very, very sad, you have had, and it's been uncovered, and you're going to have officers going to prison. documenting, officers documenting minority kids in Black communities as gang members. This one mother had the backbone to fight it. And it not only it showed that her son wasn't, but it showed, the investigation showed that there's a pattern that was going on, that officers were placing Black children, Black youth in the Cal gang file, the gang file, and putting this tag on them. And it goes to the issue of enhancements, which is a major discussion now in Southern California with the new DA. You get the person that's hung up in Cal gangs, and the person gets arrested for let's say assault or ADW, assault with deadly weapon, and all of a sudden they have these Cal gangs, and then first thing the DA is going to do, well, this was done for the furtherance of the gang because this is a documented gang member. You see, now you have the enhancement on this child that shouldn't be even in the system. What's to say that if that investigation was looked at, because I don't get all the investigations, I get some, but if this investigation was looked at and found there was some problems in the investigation that was missed, now you got a person that's in jail. You got them in jail for an enhanced time period, and now it's you've ruined another life. So those are issues. You talk about the issue of gangs. I call them, they if you look at it, depending on what you read, they call them subgroups. But I'm gonna call them what they are. They have gangs within law enforcement. You have your Vikings, you have your jump-in boys, you have, and the list goes on. You have your SWAT mafia, and and the thing is that nothing is being done about this. Hopefully we have a Justice Department will look at this. You may have some organized crime issues going on within law enforcement, and it's not unique with LAPD. It's not unique with the Sheriff's Department, because what you see in two agencies may have metastasized throughout the entire country. So the thing is that, do we have RICO problems? We have organized crime problems in law enforcement? Maybe the Justice Department needs to look at that and see what's going on, because these are real issues. These guys got tattoos, skulls. If you got a kill, then you get another marking on as a tattoo, and it goes on and on. That's not what law enforcement is about, you see. And it's going to cause the defense bar needs to be more aggressive. The plaintiff's bar needs to be more aggressive, but most importantly, the Justice Department needs to look at law enforcement and see what the hell is going on. And that's not what law enforcement is about. Now everyone is not involved in this stuff, but you have enough that's involved that makes the whole issue look bad.
For sure. I want to ask you about the bench. You've testified a lot, and I'm curious to know how do the judges receive you? Do they find your testimony helpful? And also, certainly in Los Angeles, I think it's elsewhere, there's a vast majority of criminal court judges who are former prosecutors. And so I'm just wondering if you've seen any instances of bias in that setting.
Well, I've been around, like I said, this is my 47th year, and I've known a lot of attorneys who are now judges, and I've been in their courtrooms. I've testified in front of them, and there are those that I've been in their courtrooms. They have not testified in front of them, but I've seen how they practice from the bench. So the thing is this. The thing is this: when it's time for election, all you see is DAs running for judges, and it doesn't present well, because there's other attorneys out there besides district attorneys. You have public defenders, you have private attorneys. Then you find that there are, and for those attorneys that I know that have made judge, a lot of them have done well. They have matriculated. They have turned that prosecutorial button off, and they have become fair. Now, believe it or not, the problem judges that I've seen was defense attorneys. I've known these cats coming in, they come to court late, and they'd be the first ones to put that robe on. They'll jump on those who come in late. I'm not telling you what I heard, I'm telling you what I see. And so the thing is that, it's it could go either way. The thing is that, it's like in law enforcement, like in what I do, I mentor a lot of people that want to be experts. And the first thing I tell them, you got to turn off that law enforcement button. You got to be objective. You got to look at things objectively. You bring your toolkit. The department's giving you a lot of tools to work with. Your training is giving you a lot of tools to work with. You put that in your tool bag, and then you bring the tools in, your training in, and you look at the cases objectively. And there are some that can do that, and there's most that can't. So that's it's not only from the bench, but it's from everywhere else. Let me give you an example. I was testifying in court, and this is not only in LA, but it's throughout the country where I've testified. And the opposing counsel says, well, Mr. Williams just worked at LAPD. He hasn't worked this agency, that agency, and so on and so forth. And a lot of times the retaining counsel misses that opening to rehabilitate me in that particular area. So what I do, I wait for an opening. So it normally is one or two questions down the road, because trust me, the opposing counsel is going to jump into that rabbit hole, and I'm waiting for them to jump. And when they jump, then I answer, and I says, well, look, yes, I have worked law enforcement. I've worked at LAPD, but I've worked throughout my career. I worked with other agencies throughout the country, and guess what? Investigations are the same all across the country. The same laws that govern LAPD govern Chicago, should govern New York, govern Seattle. This covers Arizona. It's not the Supreme Court didn't say, well, this is what LAPD is going to do. This is what law enforcement is going to do. You see. Now, procedures may vary from agency to agencies, but policies are pretty much the same. Now, county council or the city attorney, depends on the municipalities of different cities throughout the country. They may be more restrictive on certain things because of the risk management issue. They don't want that exposure, but it's still the same. And the jury, you get the affirmation, the nod. Oh, okay, I get it. But if you let that hang, and let the judge rule, the judge rule and say, well, I agree, Mr. Williams only worked at LAPD. Well, that's wrong. You're giving a jury the wrong information. Yes, I worked at LAPD. I worked a lot of other things too, but the what you learn in LAPD, you learn all across the country as it relates to investigations, and the jury needs to know that. And it helps the judge to know that too, because they say, oh, I didn't think about that. You see. And that's why, and again, I have a whole, I could talk about this for 2 hours, is that, the judges hear so much testimony, and a lot of it's bad testimony, until when they hear something different, their rulings or their opinions or their rulings are going to go against what should be allowed. And that's why it's important to, that's why an expert, is why they're a teacher, and they need to embrace that. I'm gonna give you one example, and I think we're getting to the point where we need to maybe open up for questions, maybe. But one example, I was in it was in the Bay Area, and one of the federal judges heard about my testimony as relates to peace officer standards and training learning domain. And that's what this is. Those are your regulatory arm of law enforcement in California, Post. And they have regulatory arms throughout the United States. Some of them Post, some are called different things. Well, a lot of experts, the majority of the experts testify, the ones that oppose me, that Post learning domains are policy. I said, no, they're not. Those learning domains drive policy. So I was asked to testify and as it relates just to that one issue under oath. And I testified that, the learning domains are or drive policy and learning domain 20, which deals with use of force, it tells you in writing, that you are to adhere to the agency who's hired you, to adhere to their policies and procedures. So they get a rebuttal witness in there from the training division, and to rebut what I testified to. And they see, again, the attorneys should have interviewed him before he got on the stand to know what the answers were going to be, and which they didn't do. And they got in the stand and testified and said, well, I agree with Mr. Williams. Mr. Williams is correct. Says the post-learning domains are not policy, they drive policy. So again, you know, this judge had the temerity to she wanted to get it right in her rulings, you see, and because she heard so much bad testimony before, until when you hear the right thing, then you sort of got a questioning about what, am I doing something right or something wrong? So I think, and that's important. The bench has got to, in my opinion, has, you know, they've heard so much bad stuff until when they hear the right stuff, their rulings are not the way they should be.
All right. Well, we have reached about the hour mark, and I know we want to leave some time to answer some questions from the viewers. So I'm going to take the first one. Speaking of judges hearing bad stuff,
You have a judge for me?
One of the viewers asked, in a trial setting, have you heard the expression testifying? What does it mean, and what are your thoughts about it?
Yeah, testifying is basically not testifying truthfully. You're lying when you're testifying. And I have, you know, on occasion, that's why it's important that retaining counsel should let experts sit in and listen to officers' testimony and opposing experts' testimony. And you'll be surprised what you hear. A lot of officers are not current with their craft. They just, one time they get current when they're studying for a promotional exam, and even then they're not current. So they just, what you call ad lib testifying. And because they're wearing a uniform, doesn't make everything come out their mouth correct. And the same thing with, you have staff officers or commanding officers come in, and they testify like they're giving a promotional oral, and you know, and not knowing what they're talking about. So the thing is that if there's any bench officers listening, encourage, you know, if the counsel asks for their expert to sit in and listen, let them sit in and listen, and it will help to stop or to correct a whole bunch of foolishness as it relates to wrong testimony in court, and I think that's important. But yes, there is a lot of testimony.
And you know, I hear the expression a lot with respect to police testimony. Is there something that police departments should be doing to head that off or to eliminate?
Yeah, there is. When I came on the department, there was a sergeant's manual, and in that manual, it stated that the sergeants are required to go to court to listen to the people that supervise testimony. Well, how many times have you seen a supervisor in court listening to their subordinates testify? I can tell you, none. None. How many times have you seen an executive supervisor in court listening to the supervisors testify? I can tell you, none. Let's cross the bench. How many times have you seen the prosecutor's boss in the court on a judge and seeing how they're handling their case? Unless it's a high-profile case, I would say none. So the thing is that, you know, there's no checks and balances. You got people holding supervisory positions. They're holding them for the sake of, yeah, I'm a supervisor. But being a supervisor in the criminal justice system is an awesome responsibility, because you've got what you're doing. You have the power to take away a person's freedom. You have a power to put a person away for life. You have a power to have them executed or subject to execution, be a legal meat. So you have awesome responsibility, and it's not a a hobby. It's a profession, and it's got to be handled as a profession. And supervision and management is not doing their job. This is not only in Southern California, but all across the country.
So speaking of that, do you ever feel conflicted uh, as an expert of being called upon to talk about the things that police departments do wrong? The malfeasance that they commit?
No, not at all. As a supervisor, you had to call balls and strikes. As when I worked in internal affairs, I did a 3 month loan, and you're looking at criminal activity for the most some instances where law enforcement officers are involved in. So the thing is that you've got to. It's not a. If you want to, I remember when I was in the military, the sergeant, he says, Williams, he says, one day you're going to be in leadership position. And let me tell you something about leadership. He says, if you want a friend, get you a dog, because leadership is very lonely position. So the thing is that I'm not in here to make friends. I'm here. This is a very serious profession. You're looking at taking away a person's freedom, and trust me, I've got the mad dog looks when I'm in the stand. I'm testifying. The detective writing notes like a shorthand and me giving to the DA. Well, hell, he should have done that, or she should have done that before that case was even filed. So the thing is that they asked the question: am I conflicted? Not at all. Do I have folk who dislike me? You bet you're right. You'll bet you're a check that a lot of folk don't like me. But the thing is that there are a lot of folk that respect. If they find that I'm on the case, they will straighten up and make sure that all the T's are crossed, all the I's are dotted. We had a high profile case, wrongful conviction case, Bobby Maxwell case. And I testified in that case. This guy, he was in prison for 40 years. And he was found, he was found not guilty. But he never knew he was free. During the course of it, he had I think he had a stroke, and he was in a coma, and he died. So the thing is that, and during the course, there was a 3 or 4 month evidentiary hearing. And we had, DAs testify. We had bring folk out of retirement to testify, and he had commanding officers testify. Everybody was on their P's and Q's with regards to testimony. Okay, I'm not saying because I was there, but they were on their P's and Q's, and they testified correctly. Now, the thing is that, what happens if they didn't testify correctly? Then I go up and I testify in that case. And my testimony was in concert with everything else that the judge had heard. So the thing is that, and a lot of things that were historical in nature, the detectives were too young to know about. Well, I knew about that stuff. And so, it was the wrongful conviction unit that was handling it in the DA's office. So I told them where to go to find stuff. And they went and found it, you see. So the thing is that, it's again, this is very serious stuff. And, you want to get it right. The district attorney should want to get it right. The defense attorney should want to get it right when they represent the client. And the courts want to get it right when they make their ruling. So everybody is looked at, because if it gets wrong, guess what's going to happen? The bench is going to be looked at, the defense attorney is going to be looked at, and the DA is going to be looked at.
Okay. Oops, my question just went away. Hang on. What happened to it? Somebody has a 3-part question that they want to ask. First part is, what's the best thing, the most useful thing that former law enforcement officers can do for criminal justice reform? The second part is there a way to organize and bring light to the armed gangs with badges in the communities and hold the police who may be in these gangs accountable? And where could they find more information about mentoring or helping or making some kind of difference in that way?
Let's talk about the, give me the first question again.
The first question is, what can a former law enforcement officer do to help make reforms in the system?
Okay. First of all, we got to define what reform is. A lot of people don't know what reform looks like. You look at what happened in Louisville, the Taylor case. They gave the family, I think, $12 million, and they had 9, they call it 9 reforms. I read those reforms. Those, I put them in quotes. Those were policy changes. That's not reform. What reform looks like, and that's my next publication, this is my next book I'm going to be working on. Reform, I'm not going to give too much of it. I want you to buy the book. The reform starts at the beginning. We create recruiting the proper individuals to come on the department. They got to come on with core values. If they don't have the core values, the department cannot give you the core values. I was testifying in Florida in a murder for hire case, and the DA asked me and said, "Well, Mr. Williams," he says, "LAPD gave you your core values, right?" He says, "No, LAPD didn't give me any core values. I came in with my core values. My mother and father gave me my core values. So if you're waiting for a department to give you your core values, that's the wrong person to be on the job. You got to have compassion. You got to have, reverence for life. You got to have, the list goes on. So it starts at the beginning. Then the next thing is that, you've got to make sure that the proper training is in place. And you got folks who come in the department, all they want to do is have something on their collar, and they do 2 years here, 2 years there, bam, sergeant. 2 years here, 2 years there, bam, lieutenant. 2 years here, 2 years here, then captain, then commander, then deputy chief, assistant chief, and then the some missions chief. Well, you've learned nothing. You are a train wreck waiting to happen. And so the thing is that you've got to start from the beginning. You got to change the system, and it won't look like the system you see now. So again, you got to get the right people at the table to talk about it. You got to turn all these cameras off and sit down in a room without the media and come up with some meaningful reform angles or approaches. So that's what's important. So you've got to make a major change in the system, and that's not law enforcement, because law enforcement deals with the prosecutorial arm, they deal with the judicial arm, they deal with probation, parole, the juvenile system. So the whole system. If you change one, the car is going to be, it's going to be a bumpy ride. But as you change one, you got to change. Everyone has to change together to make the system work. What's the second portion of that question?
The second part is what can be done about the law enforcement gangs and some of these huge problems from within the organizations?
Well, the thing is, as I talked about it earlier, is that you've got to have a Justice Department look at what's going on, because what you hear about is perhaps the tip of the iceberg, because it may be more pervasive than what the media is reporting. So the thing is, the Justice Department has to look at it, and also management. You got poor managers there. You got people who are afraid to manage. They want friendship, and you got to have leadership. So what you see, if you have gangs in your agency, then you have a lack of leadership around in that agency. If you have the SWAT mafia, if you have the jump in boys, if you have the Vikings and all this other stuff that goes on that's been identified, then that's a management problem. And if you want it gone, it will be gone. Okay. So that's how that's done. And what's the third thing?
What can someone like this viewer do to mentor somebody or to help with these problems?
Well, the thing is that you've got to have someone does. it's something like this. It's not a mentorship. You got people who are working in the system. They know the system, and they've got to make a commitment to try to help make the change. There's just like what you guys do as far as a project of the innocent. Someone had to step up to the plate and do that, and now what you're doing is making a difference in getting individuals that have been wrongfully convicted out. So there's got to be some core values that are in place to deal with these issues, and they're not easy issues. They're very difficult issues to deal with because they're institutional issues that are in place long before we were born, long before our parents were born. So these are things that have to be dealt with. It's how you deal with that. That's my answer to that approach.
So I want to ask you one other question. You mentioned stepping up to the plate, and I know that you've recently started a foundation. Can you talk about the foundation a little bit and what was the impetus for starting that foundation?
Yeah, I started as a Timothy T. Williams Jr. Foundation for Wrongful Convictions. And reason why I started that foundation was not to compete with Project of the Innocent, not compete with Innocence Project, not anything else, but to be a part of the community that will help to identify and train more attorneys to go out there, more experts to go out there, more investigators to go out there and to deal with that issue. There are studies that have shown that we have a 2.3 million person population in our prisons in this country. That's a heck of a lot of people. And then we look at the studies further show that anywhere from 2 to 10% of those are wrongfully convicted. So we're looking at anywhere from 40 to 230,000 people. Well, I'm not competing with anybody. But the thing is, what I'm offering, what we're offering is that we want to pay attorneys their prevailing rates of their wages so that we can get more people and more individuals in there. You're working with a law school. A lot of people are private. Majority of people are private practice, and they cannot sustain themselves with a $30,000 or $40,000 retainer for a case that's going to take anywhere from 3 to 5 years to work and it just doesn't work. But if you give them the prevailing wage is through grants and what we'll be providing, then that will make a major difference, and that's important. We as a community we need to help, and you got to understand that there are folk that may want to help, but they just can't. Well, we're going to take the can't away from them, and so that they can help. And I always say in my interviews, I said, we don't want to create dream teams. We want to create teams that will answer dreams for those who are wrongfully incarcerated.
Well, I say bring on the competition.
Okay.
Another viewer in the audience asked, what role would you like to see police unions play in the reform efforts?
Well, right now, the police unions are impediments to reform. And the thing is that, police unions can be, you got to remember that police officers are public servants. They're not in an occupying force. I was in the department for almost 30 years, and the unions have become they've become too political. Their politics are not my politics, and that was a major problem that we had in law enforcement, because the union, I'm paying union dues, and they speaking for me, trying to endorse somebody that I don't want to be endorsed. So number one, stay out of politics. Number two is that you have elected officials who are beholden to these unions, and that's our fault. Why is it our fault? Because we vote these individuals in, and we got to take civic responsibility, making sure that we putting people in position to make laws that's going to be beneficial for the communities in which they represent, in which we live. And I think that if until that's done, until they get out of that, then it's wrong. I'm looking at what happened on January 6th. The reports saying that there was Blue Lives Matter flags at the insurrection. One person who had the Blue Lives Matter was beating another police officer. So, so now, it's, that type of mentality is coming out of law enforcement, coming out the unions. And that it's a cancer that needs to be excised from their organization. And, having spent a good portion of my adult life in law enforcement, what we saw was a disgrace, especially with those who were retired law enforcement, active law enforcement, and even active and retired military. But the thing is that, and that's a whole other discussion, but the thing is that things have to be changed. Reform has to be embraced, and reform doesn't look like the chatter that we see talking about in America today. That's not reform.
I'm going to try to squeeze one more question in. One of the viewers asked, what do you do when you're looking at a wrongful conviction case and the officers involved who committed some malfeasance are no longer alive and can't be brought in to testify? What do you do to still prove what they did?
Well, that has been the case before. A lot of individuals, especially if the case is old, the detectives have died or maybe just cognitively impaired where they can't testify. But you do what you can do. The courts make their opinions, make their rulings. And that's where attorneys come in and make their legal arguments on that. As an expert, all I do is give my findings, and that's for the attorneys to talk about. That's not my wheelhouse for attorneys to talk about, because I'm sure this case law deals with all this stuff, and to bring that stuff before the courts and to adjudicate it for let the courts and both attorneys on both sides argue, and let the courts make it a coherent decision.
Well, we are almost out of time. Paula, did you have any other questions?
I have one question about, do you think that there are any sort of built-in incentives in law enforcement? In some prosecutor offices, the more convictions you get, the faster you climb the ladder. In law enforcement, it's like the more, arrests. Is there an incentive to that kind of pushes people toward malfeasance like that?
Well, yeah, because it brings in that anybody will do approach. Anytime you have I call it the numbers game. Anytime you have cases where for the DA, if you get so many convictions or so many death penalty cases, you move up to the 4 level, to the 5 level. Even go to the bench, you got to look at the cases you handle, and they look and see the committee in Sacramento will look and see what cases you handle, look at your legal track record, and anytime you're dealing with that, then you bring in the issues of corruption. Same thing on the law enforcement side. Anytime you work assignments, okay, I may have, well, he's out there doing a lot of police work, he gets X amount of guns. Well, next thing you know, he's working Metro. Next thing you know, they work in SWAT, or they're getting promoted to sergeant or lieutenant. Well, you start playing those numbers game, then you're going to start bringing corruption in. So they need to take those incentives away. I don't call them incentives. Those marks that you put on your belt, take them away, and then look at the person as a whole, as to what they're doing. And again, that's where supervision, management comes into place. You may not have a win or two, but your supervisor is watching you work, and he says, she's a damn good lawyer, and justice was met. No, justice is not win or lose. The justice is the right decision. I
have one more quick question about access to officer records. It's really, really difficult, as you know, to get any information about a particular officer's past, his record, her record. training, and you know, we've seen over and over in our cases, homicide detectives where it was their very first case and they made so many mistakes, but we found out about it 30 years too late. Do you have an opinion about whether certain types of information should just be more publicly available or available to, you know, attorneys who are like us looking into these cases?
When I was working at the staff level, we tried to have everyone have the curriculum vitae and active curriculum vitae. The unions fought us against that. And guess what happened? You didn't get it. It's important to know that because in the civil rights cases, you well know that experts, their CVs attached to their reports. And so you know about them. You know everything about them. When a detective or a police officer or assigned to a case, their CV should be attached to reports. The scientists now, it used to be in a day where if you're working in the lab, well, the PhD would go testify. Those days are over. You'd have to testify for the work you've done, and your CV is attached to your report, and then you got to go in there and defend yourself. So the thing is that, you know, that should be done, and that's something that the defense bar should be fighting about, the plaintiff's bar should be fighting about, and I think it's the right thing to do. That way, you won't be having all these bad cases coming out, because you'll be getting them. You'll be killing it in the front end and not worrying about it 20 or 30 years later.
Thanks.
Okay.
There we go. I think we've reached the end of our time. I want to thank everybody who tuned in and thank you for your questions. They were all terrific. Tim or Paula, do you have anything you want to leave everybody with?
Well,
I would say thank you, and thank you to Tim. He has donated countless hours to our project, and I keep fearing that someday he's going to stop answering our calls, but so far he hasn't. It's been a real pleasure working with you, and I hope we get to do that a lot more.
Yeah, and I just want to thank you for this opportunity, because this is some important stuff that needs to be out into the legal community. You don't get this in law school. And especially young attorneys who are out there, they need to know what's out there, what they can do to make their cases better, and to help to experience justice, if you will.
All right. Well, thank you to the panelists, and thank you to the viewers and participants. And that concludes our program. So everybody have a great weekend.
Thank you.
Thanks, everybody.
Thank you.
Bye-bye.